Hi, everyone. Very happy to be here. Looks like we have a great crowd here for this early morning. My name is Olta Andoni. I'm Chief Legal Officer of NFTs, also a professor and attorney in the space, practicing IP, fintech, compliance, and antitrust law. I'm very happy to moderate this amazing panel today. Since we only have 24 minutes and we have so much to talk, I'd like for our panel to introduce themselves.
Thanks so much. Hey, everyone. Good morning. My name is Andrew Bull. I run Bull Blockchain Law, which is a law firm specifically focused on blockchain technology and cryptocurrency, and I'm also a professor at Drexel University teaching blockchain and cryptocurrency law.
Hi, folks. Steve Wink, partner at Latham & Watkins here in New York. I'm co-chair of our global blockchain and crypto group. We do a lot of work in crypto and the NFT space generally, so nice to be here.
Abraham Sutherland. I'm a lawyer working on regulatory and tax issues in cryptocurrency generally, and I'm here today to talk about an important and overlooked provision in the pending infrastructure bill in Congress.
Jonathan C. Dunsmoor, Dunsmoor Law. I try to keep most of you degenerates out of jail or regulatory problems.
Perfect. Thank you, guys. We have so much to discuss. So first, we're going to talk about the securities issues. And Steve, I would like to start with you. We are already seeing a huge number of online platforms coming up, NFT platforms, I mean, and also a lot of more larger trading volume. But at the same time, we see this large interest about buying fractionalized parts of large NFT transactions in the space. So what do you think are some of the issues that the buyers, the promoters, and especially NFT issuers should consider when it comes to the regulatory and SEC framework?
Yeah, maybe we take a step back first to just kind of frame the issues here. You know, we've seen the SEC be very aggressive in the crypto space this year. In particular, Gary Gensler, when he joined the SEC, has been really, hot to get, tamped down on what's going on in crypto generally. So as a result, it's important to understand, the securities law issues here to be able to navigate, successfully that for your NFT project. So the background is that a cryptocurrency or an NFT or any sort of instrument can possibly be a security, and it needs to be analyzed under something known as the Howey test. I think most people who have been following crypto have been hearing about that. The Howey test is, it says it's an investment of money in a common enterprise with the expectation of profit through the efforts of others. Now, the concept here is like it's a passive investment, so something that we've all seen, like a share of stock in a company where you're relying on the efforts of management to create the value, but you're a passive investor effectively. So now, applying that to NFTs, your sort of classic NFT, like the Beeple, famous Beeple NFT, clearly shouldn't be a security. And the reason for that is when you look at, Beeple created the NFT and sold it, and it was fully functional at the time it was sold. And there was no expectation that Beeple would do anything further to create value in that. So there was, that central authority there wasn't there creating that value. Now, if the marketplace later creates value, additional value, or the price fluctuates, that's not the sort of profit that's picked up by the Howey test. There are cases that say specifically that's that broader marketplace is not that same sort of profit. So that's why NFTs in their pure form shouldn't be securities. But as you mentioned, we see lots of instances of people try to use NFTs in DeFi, and DeFi is under major scrutiny right now by the regulators generally, so that's an area to be wary of. And of course, as you mentioned, the fractionalization, that's a complicated area. I think there should be a path towards fractionalization that is workable, something along the lines of tenants in common or joint tenancy in real estate. That seems like a workable path. But I've seen a lot of projects that look more like that common enterprise where there's a profit that's being created by that enterprise. So,
Andrew?
Yeah, absolutely, and agree with all of that. And to extrapolate that issue as well, looking at it from the market maker side, on top of the actual individual user potentially acquiring a security. If those of you who remember, Ether Delta was an exchange that was facilitating transactions and was supposedly one of the first DEXs to ever be created. Well, unfortunately for Zachary Coburn, it turned out that they were actually transacting in potential securities on that platform. So to Steve's point, when we have these potential risks affiliated with the fractionalized ownership in the NFT itself, it's not just the users that are potentially creating risk, it's also the platforms that are facilitating these transactions, because they could theoretically be actually facilitating securities transactions. Now, Zachary Coburn settled for not that much money and then sold Ether Delta for a lot more money, but at the same time, the risk is very real. And so it would have very significant reverberating impact across the industry if, for example, the SEC came in and said, hey, fractionalized ownership, you're not having these specific identifiable different versions of whatever the economic interest is. As a result, everyone is collectively rising and falling together, and therefore it's a security.
Another interesting question is, again, staying with this topic, is that we haven't seen any kind of guidance so far from the Securities Exchange Commission or CFTC. Neither courts haven't given any precedent. Do we expect any kind of regulatory framework sooner or later regarding NFTs? And
unfortunately, what we're seeing now from the SEC in particular is just this regulation by enforcement. So, I'm not anticipating any particular guidance coming out in the NFT world, but there may be enforcement actions that arise. And one of the things, by the way, I wanted to add too on, is that we advise our clients that you have to also be careful in just the way you market your NFT, because there's an old case under this Howey line of cases that talks about how you can transform a non-security into a security by promising a liquid secondary market. It's called the Gary Plastic case. And so the concern is if you're creating this expectation of profit based on that promise of the liquidity, that together this creates this not necessarily that the NFT itself is a security, but the set of promises around it are. So that's something to be wary of as well.
So for all of you with your white papers out there, just remove that section about how it's going to be listed on secondary exchanges.
Remove that section and anything
exactly.
dealing with royalty.
And this is not legal advice, by the way.
Yeah, right, exactly, not legal advice. There's one note also, just as a clarification, because the SEC did provide guidance, but for those of you who haven't read it or don't know about it, it's very token focused, so less applicable in the NFT space.
Absolutely. Another important topic, Abe, is we're going to talk a little bit about infrastructure bill. For the crowd here, infrastructure bill was passed by the Senate and is still pending in the House right now. It was a big debate for the crypto community, especially for us attorneys. I think that for myself, because I've been in the crypto space since 2015, I think was one of those big events that we just came all around in order to not only to support and for the bill to not pass, but there is so much discussion about a specific provision, which is the 6050I. 6050I has been a little bit more neglected from the community because I think there was a little bit of misunderstanding, or maybe people did not consider the impact that this is going to have, this clause or this section is going to have, especially when it comes to peer-to-peer transactions, not only in crypto, but also as it relates to the NFTs. Abe, can you elaborate a little bit more on that? I know you've been very vocal about this topic in the space.
Thanks, Olta. So I'm here to tell you about, and warn you about, even scare you about a provision in the infrastructure bill that you might not be familiar with. This law, which has passed the Senate and is waiting for a vote in the House, means the following. If you're in the business of selling NFTs, and this law passes, when you receive payment, in many cases, you are obliged to report the social security number, name, and address of the person from whom you received the payment. And a violation can bring prison time. So I want to be really clear about this. As Olta mentioned, there are other provisions in the infrastructure bill that did get attention and debate, the so-called broker provision. Does that sound familiar? This is a separate provision. And I'm going to say again how it works, so to be as clear as possible. If you are a business and you receive cryptocurrency valued at $10,000 or more, including in related transactions or over time, it is your obligation to verify and collect the Social Security number, address, and other personal information and report it to the IRS. Under current rules, you must do that within 15 days on a Form 8300. This is a criminal statute. Violations are felonies. I want to comment a little bit on why you might not be familiar with this, and it has to do with the history of this bill. This is pending in the infrastructure bill as a tax provision. It was introduced as a way to raise revenue, and it was not discussed, it was not explored, and it was not explained because it was allegedly a revenue raiser in the infrastructure bill. Number two, the statute that is used is a 1984 statute that makes no sense applied to digital assets for many reasons. It made it difficult to understand. The statute involved concerns face-to-face transfers of physical cash, and the amendment is only 8 words long, and it changes the definition of cash to include digital assets. Another reason is it's simply extremely complicated to understand how it will apply, but be very clear about this as you read the statute. It creates a felony, and it mandates the reporting of this information from those who receive these digital assets.
So what do you recommend people do? We talk about DAOs and all that great shit, but what do these people do?
I'm in the business of, I'm here to give the legal analysis and to help explain so that people can run with this.
So what you should do is contact your congressperson and complain, because that is absolute and utter bullshit, and it will kill this industry. If you had fun in New York City, it won't be here next year.
Absolutely.
Not the city, this conference.
Abe, do we know the status right now? Because I think that we're supposed to have some updates, I think, this week or next week, if I'm not mistaken.
Another reason why it's perhaps this hasn't gotten that much attention is because when the Senate passed this on August 8th, it went to the House as a done deal with no amendments to this 2,700-page infrastructure bill, of which I'm talking about an 8-word amendment.
Which not everyone actually read or was able to read the whole.
And so that's been pending
Especially
since
directly.
August, with numerous votes scheduled that keep getting postponed. So very recently it was supposed to be voted on by October 31st. It is still pending in the House. And the sense of inevitability is perhaps one reason also why this hasn't gotten more attention.
So as you can see, we're trying to cover the main topic, so get some key takeaways from this panel today. The next topic is going to be a royalty pool. So smart contracts, as many of you here know, they allow for the resale fees to go back to the creators and artists. But at the same time, usually when you have these NFTs that travel to other NFT platforms, it's kind of hard to be able to, for the creators to be granted those royalty or resale fees. Would you like to comment a little bit more about this, Jonathan?
Yeah, royalty pools scare the hell out of me, similar to what we've been talking about regarding taxes and securities. You really have to be careful, not only who's in the pool, how did it start, what rights are you given. There is I wouldn't say bright line test. Steve's got, no offense, far more experience than I at this. But when it comes to IP and securities, those realms have not played very well in the past 100 years. And so it gets really confusing really fast. And so what you may be buying or investing in may be a security. And then you start going down the entire line of what these nice folks have talked about, and you violate that law, you violate that law, you violate that law. And then all of a sudden you have to pay one of us or the other speakers a shit ton of money to defend you against a regulator who, quite frankly, has more money than all of us. And so this is why when we talk about community and we talk about DAOs and all that other good stuff, we have to work together to make some of these regulations more clear for our industry, or it's just going to go the way of the dodo. And I cannot stress that enough. So if you see royalty pool, if you see investment pool especially, be very, very, very careful. We talked about terms of service and terms of conditions. Those things matter. You should probably save those. If you're talking about right-click and save, do that shit for that thing, because it's going to matter later. And put it in an email address that you're going to remember the address to, because it's really important.
But isn't I mean, staying on this topic, isn't the other issue because US law usually does not provide any kind of recourse for this unpaid resale royalty fees? So how are the platforms supposed to navigate this? Or
they don't. Rareable was just up here. If we have these NFTs that have royalty pools that go back, whether to the creator or to foundations or all these other kind of things, assuming that we make sure we get the tax identifying information, then we're good. And as long as we keep the reports, as Alex just said. But it matters when you start dealing with decentralized land, right? And you start dealing with all of these, possibly designated persons, meaning you're dealing with Iran or North Korea, or God forbid somebody who has, financed a terrorist operation. That's where you start getting into questions of, now am I guilty by association, which is the scariest part, because you don't know the person on the other side of the transaction.
Anything to add, Andrew?
Yeah, for sure. I mean, especially in the NFT context where there is also a collective governance component to the actual pool itself and who's maintaining that. I mean, we're talking about a significant impact and transactional timeline that could go back multiple users. So it's not one of those things where if you're early on or something along those lines, you're going to be absolved from any type of liability. So it's a very real risk that you should absolutely take into consideration when you're doing this. So also as a side note too, this just cropped up in my head, but I was thinking about, I mean, there's probably people here that play Axie Infinity all day, every day, and make a lot of money. And you want to be really careful about scholars and the way that whole process works, because each one of these topics all collectively are potentially impacting that situation going on right now.
Steve, do you have anything to add?
Yeah, sure. Well, we've seen certainly in some of these projects, particularly, open source projects where, the founders may have kind of set this smart contract in motion, and these creating these automatic NFTs and that sort of thing. But then others come in and create these little pools or clubs or whatever, or parties that are maybe trying to buy collectively NFTs or invest in them. And again, that's most likely a securities sort of arrangement in some way. It could be effectively an investment fund, right? And subject to the Investment Company Act as well. So, that's something also as a founder of that stuff. You want to make sure you're kind of keeping that at arm's length, and sometimes you can't really control that, but at least not. You want to make sure you're not sort of adopting that approach to make sure so that you're not subject to the scrutiny by the regulators when it comes around.
Absolutely, and we have only 6 minutes left. I think that the space has been evolving, and when I used to work, I've been involved in the NFT space for a long time now, but I think that the legal issues that we have seen in 2020 are quite different from the legal issues that we're seeing in 2021. Something else that I've noticed is that are we getting any kind of vibes, ICO vibes in the space right now? I think the regulators are watching. So what should the project be careful? We discussed the main, we cannot cover everything as far as regulatory issues, but I'm having that feeling that there is some flashback about the ICOs when I represented my clients around 2017, 2016.
Absolutely, could agree more. For those of you who are around that time, it feels very, very similar. I mean, also a lot of people I think should ask themselves how many legitimate projects are currently operating in this aspect of the industry as well. Because obviously a lot of people here are trying to figure out where is the inherent value in the industry, where can I actually potentially create some type of decentralized application that could theoretically allow for a community to develop their own NFTs or really share in that potential profitability. But at the same time, these legal frameworks change, and they don't always change really consistently, like even referencing back to looking through administrative rulings by the SEC. All of those are very case by case and also can't be really utilized from a precedent perspective. So it very much feels that excuse me, that way now, and I think that we're going to see some reverberating effects over the next 2 years. And all that is to say is that you can plan accordingly for these things as well. It's not like this risk is insurmountable or obscure to the extent that we can't identify it. It's very much just that we need to also conceptualize it and incorporate that into being also able to sell a rock for $300,000.
We're not trying to scare you here, but
I am.
Steve?
Abraham definitely scared me, let's say that one.
The law I'm here to talk about goes directly to this idea of decentralized in the broader sense, right? When the model for selling NFTs does not fit with this statute, right? Payments directly to your smart contract that come to you and they get an NFT, this aims to stop that. The government wants a centralized entity in there to record and report the social security number and address. The model for NFT sales is incompatible with this new criminal statute.
Steve?
Yeah, well, just getting back to your point about, the ICO craze, in 2017, we were seeing, in late 2017, we were seeing these companies that had nothing to do with blockchain saying, oh, yeah, we got to release a token, Now, I think in the NFT space, I'm not seeing that yet, but, because people have real IP and they're figuring out ways of, exploiting that and, makes a lot of sense and it fits with their business model. But I think, it's clearly, so
there.
hot. It's getting there. It's going to start attracting, those other outside interests that really don't, it really doesn't, fit, but they want to cash in. So that's what I worry about, and that's when the regulators, come a-calling.
To build off that as well, and just from a conceptualization point about the industry itself, when the securities context, I always provide maybe the counter argument to my own point about how enforcement focused the SEC is that we do only have a handful of administrative rulings, and if you go through all the fines, the majority of the time it's a slap on the wrist. That is in no way, shape, or form endorsing any of the actions that we're referring to here, but it's the reality of the industry, and they are very much a federal governmental agency and do have a mandate. Whether Gary expands that mandate, it's very clear he wants to.
Absolutely.
That's going to happen.
Jonathan?
I think we're right at that kind of going into the ICO craze again. I think things are going to get super weird in 2022. I think we're going to start seeing Gary and whoever becomes the commissioner of the CFTC, because I currently can tell you that when he testified in front of Congress, he said that 60% of crypto assets are commodities. So that's a little terrifying, right? Like, besides the taxes, besides the securities, besides the commodities issue and all these other kind of things, we have to be careful. We have to work together. I know this blockchain stuff is really collaborative, but if we do not learn from our previous mistakes of the ICO booms and busts, we're going to be in a bad position. They're going to put us in regulatory hell, and I can promise you nobody wants to be there. So if you get anything out of this, pay your taxes and then talk to some lawyer who's hopefully going to give you really good, competent advice on how not to get in trouble with some, especially the IRS. The IRS took down Al Capone, so don't fuck with them. Get competent advice.
Looks like we don't have many seconds left. So thank you so much, gentlemen, for this panel. And I wish we could cover questions, but I don't think we have time for questions, right?
Lou's saying no. Lou's
yeah. I am on LinkedIn. We're all on LinkedIn. Please feel free to reach out anytime. And thank you, NFT.NYC, for having us here.
Thanks, guys. Appreciate it.